Welcome to Open BXRX Tuesday on BronxNet. I'm your host, Kibin Alleyne, and I'd like to invite you to get social with us at BronxNet TV on Instagram and Twitter, and BronxNet Community Television on Facebook. In August of 2020, a young man by the name of Kyle Rittenhouse fatally shot two men and injured another in Kenosha, Wisconsin during a protest against police brutality. After a 2 week trial, Rittenhouse was found not guilty on all charges after arguing the shootings were an act of self defense. Joining us for discussion on the verdict is Jodi Morales, president and founder of the Law Office of Jodi Morales. Jodi, thank you so much for joining me.
Thanks for having me.
So, Rittenhouse was found not guilty. He killed two people and injured a third. Can you just explain how does this happen?
Certainly. I mean, we're talking about self-defense law. Of course, self-defense laws vary from state to state, but in this particular jurisdiction, all he had to do was feel that he was in imminent danger of his life being taken from him. Now, of course, there's a number of factors that go into this and why so many people are looking at this decision like it doesn't make any sense, right? It seems like he came into it and created part of the issue. But there was a fair amount of evidence presented by the defense team that showed that he felt that he was in imminent fear. And that's why we got the decision that we got.
Thank you for that. So, we've seen this before in 2013 following the murder of Trayvon Martin. George Zimmerman was found not guilty because he claimed it was self defense. How is the argument of self defense getting in the way of finding justice for victims in our courtrooms?
So I think self-defense is, something that we have to look at always from the perspective of the person who is feeling the fear or perceiving the fear, right? We can't say that self-defense laws, are terrible, are bad on their face, but of course, a lot has to be put into them as time evolves and as our other laws evolved to make sure that they're actually protecting people. Of course, if the tables are turned and you're in a position where you feel like your life is in threat of some sort of, really serious danger, you're going to want to have those laws, right? We can't dismiss them and we can't say that they're all bad. But it really is a factual analysis and a factual, kind of piecing together of things when that the jury has to do in order to determine whether self-defense was something that was reasonable under the circumstances or not reasonable. And I think that's where the question of justice comes in. In some situations, certain factors make that perceived threat reasonable, and in other situations, they just don't.
Now, how does this compare to the case of Abel Cedeño, a Bronx teen who was sentenced to 14 years in prison after fatally stabbing another student as a result from years of homophobic bullying? He also claimed that this was self defense.
Mhm. I remember this case very well. I practiced primarily in the Bronx, and I remember the case sort of unfolding before me as I was, in the courtroom handling other matters. And it was a very sad situation. Clearly, this was a young man who had endured years of bullying and mistreatment by others. But the case really did come down to a presentation of evidence, or rather, the defense's lack of presenting any evidence that the two victims in this case were actually the ones who were bullying him on the particular day in question. So going back to this, to the concept or to the law of self-defense, perhaps he perceived threats from other students, or at least that was the argument, right? There were perceived threats from other students, ongoing perceived threats for many years, but there just wasn't enough evidence presented to show that on that particular day, when he took action, that these other children were actually bullying him or threatening him. And so, it was a very tough verdict. I think that when you have someone who's been bullied for so long, sometimes that weighs on you, and you might perceive a threat where there isn't one. So mental health, psychiatric evaluations, all of those things really should have played into the decision here. But if we're looking strictly at the construction of self-defense, in this case, it just wasn't there.
So it's important to note that the cases that I just mentioned were all in different states. So it may vary, but when can you use the argument of self defense in a courtroom?
Sure. I mean, if you think that your life is in danger, if you are perceiving a threat and it's a reasonable, perception under the facts and circumstances surrounding you, then self-defense is available to you. Obviously, nobody wants people to just sort of stand down and be attacked. But the use of force is also something that comes into play. So, for example, if I, somebody my size and my gender is, trying to punch me, but I turn around and in self-defense shoot that person, that's not a reasonable response under those circumstances. It's different if that person comes at me with a knife and then I turn around and use a weapon to try to defend myself. Then it's a little bit more reasonable that I would use an item. But those are the types of things that really have to be analyzed in all of these cases of self-defense.
So people often blame the justice system, but this was actually decided by jurors who are just regular people. Do jurors often have complete and final say in cases similar to Kyle Rittenhouse's? And does the race and ethnicity of the jurors matter to you?
So I think one thing to understand first, before we talk about the jurors' power and their decision making, is that, in a courtroom, it's a two-person show, in the sense that the judge is making the rulings of law, and then the jury is making the decisions of fact. So this is a dance that happens in every trial in our country. The judge is just as much a part of the overall outcome as the jurors, in the sense that the judge's rulings can potentially, not potentially, will definitely determine how the jury is receiving the evidence. And even in toward the end of the trial, when jurors ask for readback, which is not uncommon, certain things that the judge has done, certain rulings that the judge has made, will eliminate certain aspects or certain facts that the jury may have heard previously. So when they're making that decision at the very end, they may not hear the same things they heard as the trial was unfolding. So, to answer the question, the jury doesn't necessarily have the final say. The way that it really should work is that the judge is maintaining fairness, making sure that all of the legal rulings are designed to create an atmosphere of fairness, so that then the jury can make a sound a sound decision based on the facts that were presented.
And do you feel like the race matters of the jurors? Because for this particular situation, it was mostly white.
I think race and gender definitely matters in terms of how a jury is going to receive information and decide on it. We all bring our unique experiences as human beings to a courtroom. And of course, if the jury pool is not aligned with some of the participants in the trial in terms of their own experiences, certainly that's going to color the way the jury renders its final decision on the facts. I think there were a lot of issues in this case in terms of jury selection, which is not uncommon. But I think, again, going back to maintaining fairness in the courtroom, it really does come down to the judge making the correct rulings so that the defendant can get a fair trial, and so that the other parties can feel like justice has been served in the courtroom.
Now, not only was he found not guilty, he actually lived to see his court date despite killing two people in public. Just so we're clear, do you think it's likely that a Black person or a Latino could take on the role of a violent vigilante and see no repercussions?
I think it's a fact-specific determination. Certainly, we can't ignore the fact that aspects of the justice system have been racist. People of color have suffered under many laws that were, to be frank, designed not with us in mind. But that's a hard thing to say. I think what matters here is the jurisdiction you're in. I think what matters is the law that is being decided, the facts of the case. Certainly, if this were a case in the Bronx, we might have a totally different outcome here. But it really is a number of factors, I think, that play into all of this.
And despite Rittenhouse and his victims all being white, how do you think race plays a part in this verdict?
I think again that race is always something that plays a part in a decision, in a legal case, because again, we come to the courtroom not leaving our experiences and who we are at the door, right? Um, I don't think necessarily that this case turns on race. I think it turned on the statute and the facts of the case. Of course, there was this underlying, issue, and that's what precipitated the protests and everything. But in this particular courtroom, I think what we really have to look at is the judge and the judge's decision making, and how it seemed, at least from day one, that he was trying very hard to skew things in favor of the defendant. So yes, there's an underlying racial current here, but I think in the courtroom, it really was this desire by the judge to see to it that this young man was not, held to full responsibility.
Jodi, thank you so much for joining us. I would just like you to tell everyone, this is a very complex issue, and as you mentioned, there's so many like loops and turns that, of the law that you really need to study. Can you tell us where people can just learn more about that and even keep up with you?
Certainly. So I can be reached by email at Jodi Morales at gmail.com. You can also reach me via Instagram at jmoraleslaw. And I encourage everybody to do research online, to look at articles, to really go back to the statutes. There are many places online where you can actually read the statute, read the legislative intent of that statute, and then from there, read other cases that sort of interpret the law. I think it's important for people to do that. I don't think people delve into understanding the law in the way that they should. And I really encourage everyone and anyone to look for those opportunities, and to also, look for trainings and seminars, and, maybe take a class in legal studies. It's really something that everybody needs to be engaged in if we're going to make changes moving forward.
All right, thank you so much. We'll be right back with more Open BXRX Tuesday.